Good morning, everyone. I'd like to call the meeting to order for the Board of Appeals. I am Stacy Aguiar, the chair, and this is for the Board of Appeals meeting for December 9th, 2022. And I'd like to start with first introducing our board members. I'm Stacy Aguiar, chair. To my right is?
I'm Richard Henderson, vice chair.
David Wiseman, member.
David Wiseman, a member.
Dana Psyche, member. Aloha.
Richard Cunningham, member, Zooming.
Thank you. That was Richard Cunningham, member on Zoom. Absent today is Matson Davis, but he will be trying to join us at a certain portion of our hearing. So we'd like to start with public testimony. We will now take statements from the public on any items on the agenda. If we have any public testifiers, if you can state your name and identify what item on the agenda you're testifying for, you'll have a total of 3 minutes, and one of us Kim will be keeping time, and at 2 minutes and 30 seconds, you will be notified as such that you have 30 seconds left. Kim, do we have any public testifiers at this time? Oh, I apologize, but can I double back to my introductions? I failed to introduce our Deputy Corp Counsel, Diana Mellon Lacey, for the Board of Appeals, and staff to the Board of Appeals is April Suprenant and Kim Tanaka. So now any public testifiers? So we have no public testimony at this time. If we can start with old business, we will be starting with the Crystal Yamamoto PLBOA 2021-00004 case, adoption of findings of fact, conclusion of law, decision in order to deny appeal of decision by the planning director dated August 17th, 2021, regarding variance from Chapter 25 zoning, Article 5, Division 3, Section 25-4-44, permitted projections into yards and open space requirements, VAR 21-0000628, location Waiakea Cane Lots, South Hilo, Hawaii 96720, TMK 3-2-4-057 -017-0000. David, can I get a motion to go into executive session? Yeah.
Pursuant to the rules of this board, I'm moving for executive session to take up some few issues with our legal counsel regarding the items that we're dealing with today.
Can I get a second?
I second the motion.
Second by Ms. Psyche. So at this time, we're going to go into executive. Oh, can I?
And the vote, it should be a roll call vote.
Got it.
Yes.
April, if we can take a roll call vote.
Yes, of course. To go into executive session, Mr. Wiseman,
Aye.
Ms. Psyche, Mr.
Aye.
Cunningham,
Aye.
and Chair Aguiar.
I and Mr. Henderson.
I'm sorry, and Mr. Henderson.
Aye.
Thank you. I'm sorry.
So the motion carries.
Motion passes.
Motion passes. Will be headed into executive session if everyone can please clear the room. Thank you.
if a discussion's going on, I can't hear it.
Not in discussion yet. We're trying to get a
Okay.
private room.
All right. Good.
There we go.
Thank you. The Board of Appeals is back in session. Great. Thank you. So let us know when she's back in the Zoom room,
And our other member.
and as well as our other board member, Mr. Cunningham. He was also needed to be admitted back into the Zoom meeting. Oh, great. So we're all back and back in session, and we are reviewing old business, the Crystal Yamamoto case. Thank you for your time while we entered into executive session. So we have two contributions on this matter. Deputy Court Counsel Jean Campbell drafted a findings of fact and conclusion of law, as well as appellant pro se Crystal Yamamoto also drafted a proposed findings of fact and conclusion of law. Have the board members received both of these communications and had a chance to review them? I hear a nod and a yes from everybody. At this time, then may I have a motion regarding proposed action?
I have a motion that. I'd like to make a motion to have the county add another term to the version. And that would be with respect to in other words, I'm adopting the version of the county, subject to a modification to include the variance, as you well stated, as the chair well stated, and you can state that for me.
Okay, but do we need a second first on your motion?
Second.
So we have a second from
Mr. Henderson.
Mr. Henderson.
It's open for discussion now.
The variance, the language.
Oh.
To be stated.
Yeah.
I see.
So I made the motion. I'm requesting the chair to,
Okay,
Um,
so the motion that Mr. Wiseman is making is to adopt the county's version of the finding of fact, conclusion of law, decision and order with a modification that states the variance was granted for the plan as submitted at the time of review, added into the county's document. So with that said, Mr. Henderson, do we still have a second on the motion? So we have a motion and a second on the motion.
Yes.
So do we have any discussion on the matter?
yeah, my motion is based on the fact that in the appellants, in a county's version of proposed findings of fact, conclusions of law, it doesn't mention that certain agencies have dealt with this, and that leads to the result that the planning department and director issued a variance in those narrow parameters that they're entitled to do. And it was based on that variance, on the planning. The variance was based on the planning that was submitted to them. And that's all they could deal with. There are other agencies that this goes on and will deal with all sorts of other issues.
Perfect. Anyone else have any comments or discussion on this matter? So
If there's no further discussion, then,
there is, so the question is, Ms. Campbell, can you issue or write a modification adding the language that the variance was granted for the plan as submitted at the time of review in granting that variance. And I believe it's an exhibit already in the documents.
Yes, I'd be happy to revise the document for you and resubmit it.
Great. So at this time, I'd like to move for a vote.
Aloha Chair. Mr. Weissman,
Aye.
Mr. Henderson,
Aye.
Ms. Psyche,
Aye.
Mr. Cunningham,
I,
Madam Chair,
Aye.
motion passes.
Thank you. Sorry. So that concludes our old business, the Crystal Yamamoto case, and we appreciate everybody's time. Ms. Yamamoto, thank you for attending via Zoom. At this time, if Mr. Davis is available, we would be moving into the second old business item. And April, is Mr. Davis available? Okay. Yeah.
Continue to watch on the regular Zoom.
Ms. Yamamoto, so at this time, you'd have to log off of our Zoom hearing, but you could watch our proceeding on our YouTube live stream if you'd like to keep watching. Thank you.
Madam Chair, I wish to move again for executive session. There's an important legal issue regarding an item that's forthcoming.
I'll second that.
And apologies to the people out here who have to, but it's good exercise up and down, you know, so.
So, Mr. Henderson, second that motion. Need a vote.
Is there any discussion? Then we need a roll call vote. Roll call vote.
April, can I get a roll call vote on the motion to go into executive session?
This is not on the Yamamoto matter?
No.
No.
It's on the board.
We're moving into old business on the
Okay.
roar.
Did you call it?
Yes.
Oh, I didn't call the case though. Should I call it before we go into executive session?
Absolutely. You need to call the
Oh.
case before it goes into executive.
My
And if it's the-
apologies.
If it's the next case, we have to wait for the board member who's coming online.
I apologize. So we are calling in old business, next case Claudia Rohr, PL BOA 2022-000025. Findings of fact, conclusions of law and decision and order to deny appeal of decisions by the planning director dated June 6th, 2022, special management area use permit assessment application PLSAA 2022-000057 and special management area minor permit PLSM 2022-000022 and director's decision dated June 17th, 2022, closure of complaint ZCV 2021-000037E, location 2212 Kalaniana Ole Avenue, Hilo, Hawaii, 96720, TMKs 3-2-1-018-006 and 007 and 010.
Madam Chair, we need to wait until the appellant is online. She's in the room, but she does not have her camera on yet.
Okay. And we have to wait to take the vote to go into executive session.
We have to wait for the other
Member?
board member, yes.
We don't have the other board member present.
Yep, please admit.
Being admitted.
And then it needs to go on the record who is recusing.
Understood.
And technically should bring back all the people we. Because we're
Should
not
we-
going into executive session.
Okay, our other members on. So,
So I have to call it
We're gonna
again.
have to do this.
Okay.
All over again.
So should we bring everyone else
Well,
back
They
in?
should be told they can come back in.
Yeah, they don't need to come.
Oh, yes, all the other people can come back in. Well.
They
yeah,
don't,
but then we,
ready to go into executive session.
yeah.
yes, we can just let them know. Huh?
But it needs to be on
Just-
the record that
I'll call it again.
the two board members.
So I apologize. We had some administrative confusion. So we do have Mr. Davis online or Board Member Davis online on Zoom, Appellant Claudia Rohr on Zoom, and Board Member Mr. Cunningham on Zoom. And we are still in session, and I will recall this item number, old business. Item Claudia Rohr, PLB OA 2022-000025. Findings of fact, conclusions of law, and decision in order to deny appeal of decisions by the planning director dated June 6, 2022, special management area use permit assessment application, PLSAA 2022-000057, and special management area permit, PLSMM 2022-000022, and director's decision dated June 17th, 2022, closure of complaint ZCV 2021-000037E, location 2212 Kalaniana Ole Avenue, Hilo, Hawaii 96720, TMKs 3-2-1-018 006 and 007 and 010. So we are in old business.
And at this time, I'm moving for executive session pursuant
Recuse.
to,
Need to recuse.
So we have two members of our board who have recused themselves from this hearing this case, and that would be Mr. Cunningham and Mr. Henderson. And go ahead, Mr. Wiseman, on your
yeah,
motion.
at this time, I'm moving pursuant to the rules for executive session to discuss with legal counsel some issues with respect to this case.
I second. Mattson Davis.
Have a second from Maston Davis, and we will now be headed into.
Right.
Oh, I'm
We'll
sorry.
Take a voice vote. Mr. Weissman,
Yes,
Mr. Davis,
Yes.
Ms. Psyche,
Aye.
Madam Chair,
Aye.
motion passes.
don't respond.
So we are currently going into executive session and we will be back. So I think Mr. Davis will be admitted into a private room.
Testing closed captioning. Miss Rohr, are you able to hear me?
Who's this?
Hi, this is Heather from planning. I was just checking our audio. I
I can hear it now, but everything that happened up to the executive session, I couldn't hear. She never confirmed whether I could hear or say, that I was in the room connected. She should have done that first, particularly because of my hearing disability. I watched it on YouTube, and so I'm ready to go after executive session. I had to switch to my iPad and watch what occurred in the portion that I couldn't hear. I clearly waved my hand. I had put my hand up before I even started my video, I believe. Anyway, this is procedurally wrong. Are you there? Hello?
I'm here. Yes.
Okay.
I'm just checking to see your audio works.
Please check the email that I wrote to the board about missing, 2 emails missing from the board packet. And I asked to have them emailed to the board members because it wasn't in the board packet. It was a November 30th and December 3rd email between Cody and I about creating a clean record. And to be honest, when I re-listened to what happened on YouTube, I was really upset and I didn't really comprehend the words that were being spoken. But I'm satisfied to go on. But please acknowledge that I was left out of that conversation, whatever was being announced, and the motion to go into executive session. I didn't really catch what that was about.
Ready? Thank you. We are back and out of executive session and we are on old business item number 2, Claudia Rohr, PLBOA 2022-000025. So at this time, we have 2 contributions on this matter. We have Deputy Corp Counsel Susanna Tiapula's drafted findings of fact and conclusions of law. And we have Appellant Pro Se Claudia Rohr also drafted proposed findings of fact, conclusions of law. Have the board members received both of these communications and had a chance to review them? And actually, yes,
Yes.
thank you.
Yes.
Thank you, board members.
At this time, I have a motion with respect to the 2 proposed versions of finding the fact conclusions of law. And I am not comfortable with either one. I believe many good points, but there's some lacking and some erroneous points. So I'm going to make a motion that the 2 versions be rejected and the board prepare its own version of proposed findings of fact, conclusions of law.
Is there a second on that motion?
I second.
I got a second from Ms. Psyche and Mr. Davis. Any discussion?
Well, just to further my, in general, my reasons for this is, Ms. Rohr submitted, several points that are consistent with, the counties, as well as some that aren't. And I feel there's, some items, important items missing, that need to be included. And hence my motion.
Any other board members for discussion? Seeing none,
I have to object
That,
for a reason.
point of
I have
order.
to object because
Point
you
of
did not.
point of order,
confirm-
we're
And Ms.
You did not confirm that I
Ms.
had,
Rohr,
I did not have, I was not in the
you-
room. I was not in the room.
Madam Chair, I'm requesting that you turn her off. She has no,
you're out of order, Ms.
This
Rohr.
is
We were in executive
time.
session on our previous conversation and discussion. That's why you were out of the room.
No, before
Okay,
that,
yeah.
you did not
Yeah.
confirm that I was connected by audio. And
Ma-
I had my hand up. I've had my hand up this whole time before the motion was made. And I wanted on the
continue.
record that everything happened.
At this time,
Before
we're going to continue
in
this.
executive
we're gonna continue
session.
the
I
hearing.
did not have audio and you did not check that.
Ms. Rohr, if I may add, you don't want to be considered as compromising the integrity of this hearing or to be disturbing this hearing, because we have a rule that you, such a person, if it goes to that point, can be excluded. I'm not saying we're at that point, but just a fair warning. So we'll address you when the time is appropriate, and I'm sure the chair will give you
Did
that
you-
opportunity.
Did you hear what I said? That you did all that without me being able to hear what was going on?
Madam Chair, I suggest we move
So
to the
we are
next-
moving, we're continuing,
We're on the vote.
we're gonna move to a vote at this time on on Mr. Wiseman's motion.
Okay, Madam Chair, Mr. Weissman,
Aye.
Ms. Psyche,
Aye.
Mr. Davis,
Aye.
Madam Chair,
Aye.
motion passes.
So this matter will be continued to the next hearing and we will take that up then. We're moving on to new business. Thank you, actually, at this time, we need to let our other two recused board members back into the room.
And I will be leaving.
And Mr. Davis, you are now excused from the rest of the hearing, and Ms. Rohr as well.
Thank you.
Thank you.
I- Okay, everyone here?
So we're moving on to new business, and are we ready? Mr. Board Member Cunningham, we're ready to start. Can you hear us?
I'm here and ready.
Great, thank you. So moving on to new business. We have case number 3, item number 3 on the agenda, Lawrence Ford et al. PLBOA 2022-000020, appeal of decision by the planning director dated February 15th, 2022 regarding complaint of operating a short-term vacation rental without permits in an agricultural project district. Locations 81-905 Makahiki Lane, Captain Cook, Hawaii, 96704, TMK 3-8-1-009-044-0000. Is there any public testimony regarding this agenda item?
No, Madam Chair.
Also in front of us, thank you, April. Also in front of us is case William Robert Gage and Rebecca S. Gage, PLBOA 2022-000021. Appeal of decision by the planning director dated February 15th, 2022 regarding complaint of operating a short-term vacation rental without permits in an agricultural project district. Location 81-905 Makahiki Lane, Captain Cook, Hawaii, 96704, TMK 3-8-1-009-044-000. Do we have any public testifiers on this agenda item?
No, Madam Chair.
Thank you. April, can you verify that each appellant provided a notice of today's hearings to the surrounding property owners in accordance with BOA Rule 8-11D, which is 20 days prior to the hearing, and has filed with the board proof of service of the hearing on the property owners within 300 feet?
Yes, Madam Chair. One moment, please.
Thank you. Yes.
Yes, Madam Chair, both parties have filed to surrounding property owners.
Thank you for that verification, April. So at this time, can I get the names and appearances of the parties for this matter, starting with the appellants and their counsel, please?
Board. Members of the board, my name is Michael Matsukawa. I'm the attorney for the appellants who are also present in the room.
Great, thank you. And this is for Mr. Gage's case.
Yes, ma'am. William Robert Gage Jr. For our case, by my wife, Rebecca, or Becky Gage. Please call me Bob. Might I make a small correction to the notices? That was a 500-foot notice that was sent, not, I thought I heard you say 300, so.
Great, thank you for that clarification that the notification was for property owners within 500 feet of the property. May I also get the names and appearances for the landowner? And you folks are both welcome to take a seat up at the front table.
Madam Chair, board members. My name is
Morning.
Patrick Wong, and I'm here with my client. Property owner, Beata. Her husband unfortunately is out of country and could not be here today.
Speak
Can you-
closer to the microphone.
Closer?
Yes.
You want me to restate everything I just said?
Yeah, that'd be great.
Okay. For
So
the
we
record,
we are on record and recording. Thank you.
okay. But just to be clear, the last time I was handed a mic was at my son's wedding. Again, my name is Patrick Wong. I'm here with my client Beata, who is a property owner. Her husband, Brian, is not in country at the moment. And we apologize for that.
Madam Chair, in the interest of full public disclosure, I'd like to reveal the fact that Mr. Wong was the attorney for a homeowners association that I sit as a vice president and board member, handling a contract matter several years ago. If anyone has a problem with that, please let me know. If not, we'll proceed. And with a comment I can't resist making is that the statement I just made about public disclosure is something justices in the U.S. Supreme Court should think about sometimes. Thank you.
Thank you, Mr. Wiseman. And if I can also get from the planning department names and representation.
Good morning, Deputy Prosecuting Attorney Susanna Tiapula, also appearing with Deputy Corporation Counsel Susanna Tiapula, also appearing with Deputy Corporation Counsel Jean Campbell, representing Planning Director Zendo Kern.
Great, thank you. I'd like to note for the record that the parties agreed in a pre-hearing conference to consolidate the taking of testimony for these two matters for efficiency purposes, although separate decisions will be rendered in each case. And I'd like to note that and affirm that the board has read and reviewed all relevant documentation. So for the parties, are there any housekeeping matters we need to discuss before proceeding with our hearing? Mr. Matsukawa.
Yes. Referring to the record on appeal, some of the complaint letters to the planning director and the director's responses are in here. They're true and accurate, but the names of the parties were redacted. So we don't know, for example, the complaint letter that appears on page 3, we don't know who it is who made that. But, and the same goes for the response letters. They're redacted as well when you look at pages 22 going forward. So what I recommend is to ask if the parties can stipulate that the complaint letters came from my clients, the appellants listed in the petition, and that the response letters that were redacted went to them, which is the basis for their subsequent petition for appeal. That would eliminate the necessity of calling witnesses to say, yeah, that document looks like the one I filed, and that document looks like the one I received. So that otherwise, we need to make a connection between the complaint in page 3 and the response.
So Mr. Matsukawa, my question is, because the record on appeal was provided for you to meet the order deadlines for making your witness list and calling your witnesses, why are we hearing that statement only now in your concern for the redactions?
I'm not objecting to the redactions. I'm just trying to make sure that we can make this hearing efficient by agreeing that the complaint letters came from my clients, the appellants, and the response letters that are redacted went to the appellants as well. I don't think there's any disagreement that is true.
Do the board members have any? Does the county or the landowner have any issue with us answering this question or affirming?
On behalf of the landowner, quite frankly, Mr. Matsukawa raised that issue with me earlier today. And I told him that he could certainly represent to the board that it is from his clients and it was received by his clients. They're going to provide testimony. They can certainly speak to the content of the document. So to the extent that no one objected to the record of appeal, the record speaks for itself. I think it should stay as is.
Thank you for that response. Does the county have a statement to make?
Only that the county did have a duty to those individuals to respect their confidentiality, and without that waiver, we cannot release that information. If they wish to do so, we have no objection. We'll defer to the board.
Thank you. Do any of the board members have any comments or questions?
I agree with corporate counsel that it's already been set and done and agreed upon, and so I trust that it is what it is.
Anyone else? Okay, so hold on. So at this time, I'd like to ask if the parties would like to make their opening statements regarding the case. Starting with the appellants, Mr. Matsukawa.
One more housekeeping matter. The petition of the appellants to the Board of Appeals, for some reason, was not filed with the record on appeal package. It was filed separately as a separate document. We have identified that as our appellant's exhibit number 14, and it's been posted on the Board of Appeals website. But for some reason, like I said, it was not included in the record on appeal package.
So you're saying the petition for the appeal is not part of the record on appeal?
It was not included in the record on appeal that was published. It was published separately. I don't know why, but it should be part of the record on appeal.
Does the county have a comment on that?
County would just note that the entire proceeding is part of the record.
Noted. Agreed. Mr. Motzko, any other housekeeping items? Thank you. So if we can proceed with our hearing,
If I may.
oh,
Chair?
yes,
In terms
Mr.
of housekeeping, there is a motion that was filed and it responded to, and I'm asking whether or not that motion is going to be heard before the proceedings begin.
So can you be specific on what the motion is that you're referring to?
Sure. So.
And
under-
speak loudly into your microphone.
Speak into the mic.
Thank
Under
you.
the rules, it provides for motions to be filed with the board in advance. The landowners and myself did file a motion for summary judgment. Although the rules say motions shall be filed, it doesn't specify what motions this board will entertain. To the extent that the motion for summary judgment can also be construed as a motion to dismiss, because that's what we're asking for. I believe we should address the motion prior to opening statements and prior to this board deliberating and receiving evidence and witness testimony. That's my position. Thank you.
Thank you. So to address that, can we hear your motion?
And Mr. Wong, the motion was opposed in writing.
Excuse me?
Was the motion opposed?
Yes, it was.
And was there any reply or just a motion and a memorandum in opposition?
There was a motion with the memo in support that I filed.
Right,
There was a memo in opposition, and there was
Okay.
also a reply.
a reply, okay. So,
So go ahead, Mr. Wong.
Thank you. If you take the time and if you go into executive session to deliberate over this issue and review the motion, I'm assuming with the chair's statement early on that the board has received all the documents and has thoroughly reviewed all the documents. With that said, the motion asked that this board review what's been submitted and render a decision to dismiss this action on the basis that the director did not erroneously rule as he did in dismissing the underlying complaint. There's no legal basis for the underlying complaint. If you look at the motion, if you look at the underlying complaint, it speaks to and asks the director to apply state law and also to apply a land use commission decision, which we all know has been overturned by Judge DeWeese and is pending current review at the appellate level. If the underlying complaints can cite to the land use commission decision, then so too can we rely upon what the current state of the law is in this jurisdiction as rendered by Judge DeWeese. It's an exhibit to my motion. I offer it to you for review. There's no doubt that there is no application of the short-term vacation rental ordinance to my clients. It doesn't apply as the director determined. It doesn't apply, and there is no violation of that statute.
Mr. Wiseman.
So, as we know, Mr. Wong, those of us in the legal arena, summary judgment has as its basis, there is no material fact in dispute. Is that your position? That is in your submissions.
That's correct.
Thank you.
Any other questions from the board for Mr. Wong? Do Mr. Matsukawa and Mr. Gage, do the appellants have a response?
Yes, we do. We filed our objections earlier. Basically, they're in three parts. First, there really is no rule published by the board that provides for a motion for summary judgment. It's like asking an appellate court that's hearing an appeal to render a summary termination of the appeal based on some motion and argument. The appeal is to consider all of those issues. So first of all, without a rule authorizing a motion for summary judgment, we feel the motion is improper. You should not be hearing that. It actually refers you to the merits of the case, which you can decide on appeal. The second is, and we will admit the authenticity of the Rose Hill decision that the circuit court made. But if you read that decision, it makes clear that none of the parties in the Rose Hill case had properties that were set apart as a special county agricultural project district. The properties in this case all were put into the county agricultural project district per county ordinance 97-133. That is the governing standard, 97-133, and the county code that explains what an agricultural project district is. By state law, the legislature allowed the county to enact special zoning measures affecting land in the broader state ag district. So the county in this instance did enact such a special ordinance for this specific area, Makahiki Lane, as a agricultural project district. The county council also enacted special ordinances governing what use can be made of land put into its county agricultural project district. The petitioners have filed, as noted in their petition on appeal, allegations that the planning director did not address the question of what uses are allowed within a county agricultural project district. If you look at the response letters in the record, the planning director did not address that question. So they brought this appeal to this board to ask, first of all, does this case involve land in a county agricultural project district? The land also happens to fall within, as I said, the broader state agricultural district. But the governing law is the county ordinance and the county code as to what can be put on land in the county ag district. It's really undisputed in terms of facts that the landowner is using their property for transient accommodation purposes for a fee for compensation. And if you look at the question in context of the county ag project district ordinance, is that a permitted use? That is for you to decide. Therefore, the motion really is not a proper motion because it's asking you to decide not on the basis of the county ag project district ordinance, but some general proposition that this is a farm dwelling, so it's okay. Thank you.
Thank you. Mr. Gage,
Yes, ma'am.
or
First, I know I've got an accent. I am not used to talking on microphones. Are y'all able to understand me at this distance?
just
Okay.
speak into that. Yeah, you're great.
Yes, okay, thank you.
Speak loudly into the microphone.
As I understand Mr. Wong's motion, he's concerned about the infamous Rose Hill case. Not a lawyer. Y'all may need to swear me in after a while, and I'm underdressed compared to these other fellows here. I was told that church attire would be okay, so this is no disrespect intended. But as I understood the Rose Hill case and the judge's decision, everything I could find, that whole situation was about a short-term vacation rental as defined by the county ordinance, which means a non-hosted situation. So to this non-lawyer, that whole thing just is totally irrelevant. And I offer that as my thoughts on Rose Hill.
Thank you.
Thank you. Mr. Wiseman?
Yeah, Mr. Masakawa, you mentioned about the rules with respect to summary judgment. But in the rules of practice and procedure for the board, and it's on section 3-12 motions under letter C. No, I'm sorry, under B. Any motion. I concur with you that summary judgment perhaps should be mentioned there, but it wasn't necessary pursuant to the rules. It says any motion can be filed in writing to the board, and then there's opposition provided and so on. So it doesn't specify dispositive motions, which is what a summary judgment is, of course. It doesn't specify as to the classification of motions. So with respect to the propriety of Mr. Wong filing a summary judgment, and we've had him before in other cases, it is allowed, it is proper. So I just want to point that out.
Do I have any other questions from board members? Oh. And Ms. Tiapula, do you want to respond for the county?
Just briefly, we concur with the landowner with respect to the fact that there are no issues of material fact in this case, and it is a legal argument being presented today. We do submit that the planning director's decision was not erroneous, and we concur with landowner.
Mr. Wiseman?
Yes, Ms. Tiapula, how do you respond to, I'm sorry, what was your name again?
Mr. Gage.
How do you respond to Bob's statement that this really doesn't deal with the short-term vacation rental, it really deals with the uses in the agricultural?
Short-term vacation rental, the entire statute does
Ms.
not.
Tiapua, I'm sorry, could you get closer to your microphone, please?
Certainly, and I'll also speak louder.
Thank you.
The short-term vacation rentals ordinance does not apply to the property in question. And we argued that.
But my question was, he was focusing on agriculture use.
And we can address that. Within an agricultural district, there is no provision that limits the landowner from renting a portion of their residence. There is nothing to address the duration of that rental within the agricultural use. This is a legal argument, and we would ask the board to rule as such.
And Mr. Wong, on my question, do you have any comment on that one?
Yes, I do. Thank you very much for asking the question. With respect to Mr. Gage's argument, I believe it's misplaced. In his original complaint, he does reference wholeheartedly to the Land Use Commission underlying order. The basis of his complaint is, and he points to within his petition, the underlying order from the Land Use Commission, which at the time held that no vacation rental or short-term rentals will be allowed in the agricultural district. That was clearly reversed on that point by Judge DeWeese. I've attached Judge DeWeese's order, findings of fact and conclusions of law in my motion, I cite to the relevant sections. Quite frankly, whether it's hosted or not hosted, there's a provision in the ordinance that deals with unhosted short-term vacation rentals. That's not what we have here. There's no dispute that my clients live on the property. There's no dispute that that was what was referenced as the basis for their complaint, that there's no permit for a short-term vacation rental. So focusing on the complaint, the only thing you need to look at is whether or not the director was correct and affirm his decision that the short-term vacation rental ordinance does not apply. We also know that the planning department is working quite diligently on rules that deal with hosted rentals. It's not before you yet, but you'll see it. And I think in terms of timing, once those rules are adopted and my clients apply for and secure their permit under those rules that currently are not in effect, and there's a violation, then I think then it would be more prudent for the neighbors and the appellants to raise those issues. Currently, there's no violation of law. And you're
thank you.
perfectly suited to dismiss this action at this moment.
Thank you, Mr. Wong. That's all I have.
Any other questions from any board members or statements? Mr. Matsukawa.
I'm afraid that we're getting a little confused now, as I noted in my pre-hearing papers, that if we don't be careful, we're gonna venture off in the wrong direction. In the record on appeal, of the 8 complaint letters that were submitted, 5 of them specifically allege a violation of the Egg County Agricultural Project District law. Not just SDDR, not just farm dwelling. What Mr. Wong is asking to do with the county's cooperation is to ignore the admitted fact that this land is in a county agricultural project district, which has its own rules and regulations. Shifting to, is this an SDVR or is this a farm dwelling? Those are red herrings, but unfortunately, in context of the whole subject being discussed in the public arena, people seem to confuse them as all being one and the same when they are actually different. What is before you are complaints pertaining to activity in the county agricultural project district, which has its own rules and regulations. The Rosehill cases has nothing to do with the county agricultural project district. You read the judge's decision, there's no reference to that fact.
Thank you, Mr. Matsukawa. And I will state for the benefit of everyone's interest, in a court, when a motion's filed, the movement gives his argument, the opposition gives their argument, and then in most situations, there's a reply, and that's it. Otherwise, there's a bouncing ball, keeps going back and forth and back and forth. And also, in my experience, I would not allow 2 people. You don't represent Mr. Gage.
No.
Yeah, you're representing yourself. You're representing yourself, right?
Yes.
Yeah. Okay. So, yeah. In any event, that's just some dicta to the case. Thank you.
Any other comments or responses?
All right. At this time, Madam Chair, I'm going to move this summary judgment issue. I'm going to move for executive session. I need some. I think we should consult with our counsel in this matter.
Can I get a second?
I'll second that motion to move into executive session. Richie
And
Henderson.
Mr. Henderson seconds that. Can we call a vote?
Yes, ma'am. Mr. Weissman,
Yes.
Mr. Henderson,
Aye.
Miss Psyche,
Aye.
Mr. Cunningham,
Aye.
Chair Aguirre,
Aye.
motion passes.
So we are now headed into executive session. Thank you.
More exercise.
Okay, thank you. We are back from executive session. We're back in regular session. And at this time, I'm going to call a lunch recess. And we will adjourn and come back from lunch recess and reconvene at 12:30. Do I need a vote to adjourn to go to lunch?
Motion to adjourn for. Motion to adjourn for lunch.
My second. Oh,
I apologize.
we're all
All
in
right, so
favor.
we're not adjourning, we're on a break to go to lunch and motion, all in favor, aye.
Aye.
Motion passes. We are on a lunch break until 12:30, where we will be back online. Thank you. We're ready. So we are now back from our lunch break and on new business, hearing the Lawrence Ford et al. PLBOA 2022-000020 and the William Robert Gage and Rebecca S. Gage PLBOA 2022-000021 case. And I believe on the floor right now is the matter of the motion for summary judgment. So that being said, do I have a motion from the board to address that motion on the table?
I would make a motion that we consider these motion for summary judgment and decide on how we're going to proceed from there. Or does it need to be more
It has to be
affirmative?
affirm.
So I would make a
affirmative
motion that we uphold the motion for summary judgment.
Do I have a second from the board?
I second the motion.
Is there any discussion?
Is I was wondering if Mr. Wong did a reply to the initial responses,
Yes, we did follow a reply.
and what document was that? The date?
One second. Actually, I stand corrected. I don't see it within my list of documents. What I do see is our responsive pleading to appellant's motion to exclude references to the Rose Hill matter and our subsequent pre-hearing brief.
So that was your reply to their replies to the summary judgment was just your
To their memorandum.
redacting the Rose Hill from it.
Correct.
Thank you.
Is there any further discussion by the board?
Yeah. And in reviewing the summary judgment and all the exhibits attached to it, I still, not still, but I'm of the position that the directors, I'm of the position that the director, that they correctly applied the Hawaii County Code when they close the complaint. And that it's not their province to get involved in private property disputes. And although there was some talk about short-term vacation rental, Mr. Gage stated that that was erroneous, but still it was determined to be a bed and breakfast. I believe there was some reference to that. But and I still believe that the planning director's decision in this case. Is there a motion on that? Or no, we're just dealing with.
So right now we have a motion to affirm
Right.
the summary
And that's been
judgment,
seconded, yeah.
and that's been seconded, and now we're in discussion amongst the board members, amongst ourselves on, before we go to vote. So if any board members have anything they want to say about their position or perspective. And Mr. Cunningham, Board Member Cunningham, don't let me forget you there if you have something to say as well.
Thank you. I'm here.
All righty. Any other discussion by board members?
Just to state that summary judgment is proper when the record indicates there's no genuine issue as to any material fact. And therefore, a moving party would be entitled to judgment of law. That's all I have.
Thank you. So, and we have no other discussion, then I would like to, April, can we move to a vote on this matter?
So the motion is to affirm the motion for summary judgment. Mr. Henderson? Mr.
Aye.
Wiseman?
Yes.
Ms. Psyche?
Aye.
Mr. Cunningham?
Aye.
And Ms. Aguiar?
Aye.
Motion passes.
So that closes this case with that motion for upholding or awarding the summary judgment. At this time, we will move on to our next item. And oh. Apologies. So with that said, Mr. Wong, would you like to be the party to prepare the order?
Yes, we certainly will prepare the order.
And then you would issue it to the appellant, and appellants know you have 15 days to respond, and we will take it up again, take a vote on that in the next hearing.
Absolutely, we will do that.
Thank you. Is everyone good with that? Mr. Wong will move with the order.
Clarification, Chair, the order will be due in how many days? 15? And respondents have 15?
Believe the order is due.
Just want to make sure the
It
record's
is,
clear.
the order is due in 15. Respondents then have 15 days after that to respond, if any.
Madam Chair. Yeah, I'd just like to state that at this stage of the proceedings, if there's a response to the proposed order, it's not to re-argue the whole case as was done in the summary judgment documents.
Thank you. Oh, so Mr. Wiseman, can you please repeat
I was
that?
just stating, as you heard, Mr. Wong's going to prepare a proposed order granting summary judgment, affirming the director's decision, which dismisses the case. And then you and your husband and Mr. Mazikura will have an opportunity to respond to that. Okay? And there's a time limit. And my statement was basically the response is not to be a whole repeat of all the arguments that we already have. So that's all.
So we thank you folks for all appearing and being present and making the effort to come here. But next item on the agenda,
Chair, if I may, before we move on behalf of my client, I'd want to thank the board for allowing.
I'm sorry,
us to
sir,
present.
please speak louder.
Do we still have to address, is this grant in response to the Ford proceeding and the Gage proceeding.
Correct.
Okay, with that said, then I'm assuming we will be able to leave.
Yes,
And on
thank
behalf
you.
of my clients, I want to thank the board for its time and its effort in its review. Thank you very much. Have a great day.
Thank you. So next on the agenda is oh, you're right. We do have to vote on each reading of each case number separately. And so it's the same issue, but the motion to affirm this motion for summary judgment is on the file for, is only filed.
So we still have to deal with the Gage.
No.
For the record, the motion was filed in both proceedings.
So your motion, Mr. Wong, is on file for both case numbers.
That is
We just need to vote for, on the record, that both cases are awarding your motion for summary judgment.
That is correct. Thank you.
So April, can you clarify our vote for the first case? Shall I read that case into record and then hold another vote for the second case? So our vote in affirmation is for the case Lawrence Ford et al. PLBOA 2022-000020, appeal of decision by the planning director dated February 15th, 2022 regarding complaint of operating a short-term vacation rental without permits in an agricultural district project. Location is 81-905 Makahiki Lane, Captain Cook, Hawaii 96704, TMK 3-8-1-009-044-0000. Can I get a motion for the matter of motion for summary judgment on case William Robert Gage and Rebecca S. Gage, PLBOA 2022-00021, appeal of decision by the planning director dated February 15th, 2022 regarding complaint of operating a short-term vacation rental without permits in an agricultural project district, location 81-905 Makahiki Lane, Captain Cook, Hawaii 96704, TMK 3-8-1-009-044-0000.
Mr. Gage, you want-
Go ahead, Mr. Gage.
Madam Chairman, I'm a little confused, pardon me. Did we file a motion in opposition to this? motion
Correct.
Back then? Did we? I didn't bring all my files with me. I'll never make that mistake again. But I'm not entirely sure that
Yes.
we did what y'all are fixing to vote.
You did, and we are in possession and have reviewed your document that was also on our electronic files. You started with an email to us in opposition of that on Wednesday, October 5th. So it is your attachment says it's referenced the Gage's response to landowner's motion for summary judgment. And we have received that. Okay, so
Here,
we're on open is, do we have a motion?
Okay, I'll make a motion that the present previous ruling just a short while ago, granting summary judgment with respect to I'm getting mixed up with the names here. Well, no, we granted it to, yeah. The landowner thing. Mr. Wong. Yeah.
Mr. Matsukawa.
No, Wong's claims as well. Is there any-
Is
Just a moment. So again, my motion will be with respect to the previous ruling just made granting summary judgment to the landowners Ryan Neal and Beta Zanoni. Also applies to Mr. and Mrs. Gage and should be incorporated in that case.
So do I have a second on that motion?
I'll second that motion.
So April, can
Any more
we,
discussion? For the record,
oh, my apologies. Any discussion by the board?
This will then have it applied to both appellants that are in the,
Both representing their own parties, that them, Mr. Gage Pro Se and Mr. Matsukawa. So we are voting on that vote or this judgment being applicable to both cases.
thank you for the clarification, Chair.
I'm sorry, is also applicable to the second Gage, Mr. Gage's case.
And Mr. Gage, for the record, did participate in the summary judgment motion, and we do have his arguments that were submitted.
Can I address Mr. Gage? Okay. So do I have any more discussion by the board? That said, April, can we go to vote?
okay, so a motion in Mr. Gage's case to affirm the motion for summary judgment. Mr. Wiseman,
Yes.
Mr. Henderson,
Yes,
Ms. Psyche,
Aye.
Mr. Cunningham,
Yes, yes.
Madam Chair,
Yes,
motion passes.
thank you. So the motion passes and Mr. Wong, your document will be written for both cases, correct?
I will prepare two separate orders and I will circulate it to both Mr. Gage and to Mr. Matsukawa.
Thank you.
Thank you.
Mr. Gage, although we were not able to hear any further testimony because we were in a vote situation, do you have something you'd like to say?
Yes, ma'am. Pardon. I was going to suggest that you let us have one little tidbit of opportunity to present something to you before you took the action that you just did. Perhaps if you would consent.
Sorry, I can't hear the gentleman.
I beg your pardon, sir.
Yeah, to speak.
I was going to ask with your consent, possibly after you hear what I have to say, which is on record, Mr. Matsukawa will have a number.
And
of-
unfortunately, we can't hear and we cannot hear any further testimony, and the testimony portion was during the arguments before us prior to our recess. So the case is dismissed and we thank you for your time and we appreciate your time in front of us. And if honestly, I believe that laws are changing and you may have the opportunity to pursue what you need to pursue moving forward. But at this time, the case has been dismissed.
Might I say that I don't notice that anybody has made any testimony today, but you've acted. And I guess we will live with it and take the next appropriate steps, whatever that may be. Thank you.
Thank you. All right, moving on. We're moving on to the approval of minutes from our September 9th, 2022 and November 4th, 2022 meetings.
I think you have to take each individual.
Okay, so first let's start with the September 9th meeting minutes. And if I may have a motion to approve the minutes from the September 9th, 2022 meeting.
I move that we approve the minutes from the September 9th, 2022 meeting.
Do I have a second?
Second.
Thank you. April, can we get or do we have any discussion on those meeting minutes from September 9th?
Minutes can be all in favor, assuming it's all in favor.
I see. Thank you. All in favor?
Aye.
Aye. Mr. Wiseman, are you in favor?
Yes.
Mr. Cunningham?
Abstain. I wasn't present at the meeting.
Thank you. So now moving on to the meeting minutes from our November 4th, 2022. Let me get through the special session first. Okay. Oh, on the September 9th. Okay, yeah.
Meeting minutes from meeting minutes
From
from
the-
executive session, which you also.
Okay, so that's also from the September 9th, 2022 meeting. Can we also get a motion to approve executive session meeting minutes? Is there a motion?
Yeah, make a motion to approve the executive session meeting minutes.
For September 9th? Is there a
Yes.
second?
Second.
Thank you. All in favor?
Aye.
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 One abstain.
Minutes are approved. So now let's address the November 4th, 2022 special session meeting minutes. Can I get a motion to approve that?
I move that we approve the special session, November 4th, 2022, both the hearing minutes as well as the executive session minutes.
Perfect.
A second.
Can we get a all in favor? Aye.
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 Yeah, so we have 4 ayes and Mr. Cunningham.
One abstention, not there.
Abstention. So the meeting minutes are approved. So do we have, for administrative matters, do we have any update on appeals filed to the Board of Appeals?
Madam Chair, I have no updates at this time. Sorry. Madam Chair, I have no updates at this time.
And or April, do you have any updates on
Just-
outstanding?
Sure, just
petitions?
briefly for the January 13th meeting, we currently have one case, Uliano, case number ending in 39, and we will be doing officer elections at the next hearing. So hoping everyone can attend.
Great, thank you. Are there any announcements at this time, anyone?
I move to adjourn.
Do you have a second?
Second.
All in favor of adjourning?
Aye.
Aye. Thank you, everyone.
All right, thank you. Good day.
You too. The Board of Appeals meeting, December 9th, 2022 is adjourned.
Sure.
And